Okay, so I'm going to just get us started in the introductions as I see participants continue to slowly trickle in. I want to thank everyone for coming to our fifth and final session of our arbitration advocacy in the virtual and hybrid world training. Once again, I want to thank PMI Philip Morris for sponsoring this series, which has allowed us to present it free of charge and provide CLE credits for everyone. So today's session is going to cover what arbitrators look for when deciding the case. And I do want to, before we get started, just give a few little housekeeping things. As this is set up as a Zoom meeting, we hope that you will keep your cameras on so that we can see you, but please feel free to pop any questions in the chat or raise your hand, and we'll do our best to get all of our questions answered during the program. We will also have some time at the end of the program reserved for Q&A as well. So if you don't get your question up during the program, during the discussion, you'll have time to ask the question at the end. Great. So once again, thank you to everyone for attending. Thank you to our speakers. I'm going to do just some quick introductions. My name is Mia Levy. I am the Vice President for Global Development of CPR's Dispute Resolution Services. For those of you who might not be familiar with CPR, just quickly, CPR was established in 1977 as an independent nonprofit organization that promotes the prevention and resolution of conflict to better enable purpose. CPR Dispute Resolution is a boutique provider of leading edge dispute management services. So we leverage the resources from the CPR Institute, our think tank, which brings together parties and advocates in dispute management who share best practices and generate tools for facilitating dispute prevention and resolution. Our panel of distinguished neutrals is a carefully curated, diverse group of prominent, experienced subject matter and ADR experts based in more than 30 countries. And we're really fortunate to have 3 of those neutrals with us today to discuss what goes on in their head during the arbitration proceeding and what they're thinking about when they draft their awards. So just quick introductions for the 3 of them, even though I'm sure you all already know who they are. Judge Timothy Lewis is a former federal appeals judge and is co-chair of Schnader's ADR practice group, where he serves as a mediator, arbitrator, settlement counselor, and trial and appellate practitioner. As a federal judge, Judge Lewis tried, decided, and authored opinions in all matters that came before the federal courts. And he now brings that as co-chair of Schnader's ADR practice group. He brings that experience in his development of a national and international ADR practice involving many of the world's leading corporations. Dana MacGrath is a leading independent arbitrator with over 2 decades of experience in international arbitration disputes and sits on the roster of several ADR institutions, CPR included. Dana has been instrumental in developing international arbitration and has given her time to several organizations. She was co-chair of CPR's Rules Revision Committee for our most recent iteration of our arbitration rules, and has just finished serving as president of the board of directors of Arbitral Women, among many other organizations that she sits on. And finally, last but not least, Cecilia Flores Rueda is a practitioner and arbitrator who handles complex and high-stake international and domestic arbitration cases and represents clients before federal and local courts. She brings experience from her prior work for major law firms, but also from her prior appointment as Secretary General for the Mediation and Arbitration Center of the Mexico City National Chamber of Commerce, where she was in charge of administration of mediation and arbitration proceedings under multiple rule sets. So I do want to thank our three panelists for joining us today. For those of you who just joined, I want to remind everyone that as a Zoom meeting, please feel free to raise your hand or pop your questions in the chat box, and we'll try to get to them. But we will also have time at the end reserved for questions and answers. I'm going to go through several issues that we identified as important topics that arbitrators think about as the proceedings go on and think about as the award is drafted. So we're going to address each of these questions in an open discussion. So I'm going to let everybody take a chance at answering the question. And then, of course, if anyone has questions on those, feel free to weigh in. So to start off, we thought it would be important to discuss what makes effective post-closing information. So do arbitrators prefer written submissions? Do arbitrators prefer oral arguments, or should parties be doing both? And thinking about that in terms of whether it's different for small or larger cases, and what kind of information in there is effective. So I'm going to start with Cecilia.
Oh, thank you, Mia. And well, of course, thank you all and the CPR for having me this morning and with this very nice topic. I would say that, well, as always, there is no general rule for deciding whether to make the closing submissions at the end of the oral hearing or to submit them in writing short after the hearing. Everything has its pros and cons. On the one hand, if parties submit them at the end of the hearing, you save the time that counsel would take to prepare them. But on the other hand, counsel could omit important information addressed by the witnesses or by the experts given the rush. And also, presenting them orally may allow the parties to make emphasis and make an impression that would be difficult to achieve in writing. There's always like more, you can, well, it depends if you are good at writing or good at your oral impression that you can make. It all depends. I think also that when it comes to oral submissions, I would recommend the parties to be very selective. Don't try to summarize the written briefs. It's rather about summarizing the points and the issues that have arisen during the hearing and discrediting the opposing party. But it is not a summary, and the arbitral tribunal can have their own summary. It's more like having the freshness of the hearing and just making a summary of what happened during the hearing. And it's also very important when it comes to written submissions that I like doing that arbitrators list and the points or the issues that would like the parties to address. An address should take that, well, they have to address that. Sometimes the parties really just make, as I said, a summary of the case and really forget about what the arbitrator said, or they are trying to find out why did the arbitrators ask for those issues, and they get mixed up. So I would say try to be very clear, try to summarize what happened during the hearing, try to discredit what the other party said with your evidence explained or exposed at the hearing. And if there is something that you think that the arbitral tribunal might have missed, that's your chance to address that point. And if it's a large or a small case, yeah, I think that the things could change a little bit. I would say that if it's a small case, I'd rather prefer having oral submissions. And when it is a large case, of course, for the volume of the evidence and the memorials and everything, I would prefer having written submissions. But as I said, it all depends, and that's the beauty of arbitration, that we can be flexible and adapt to what it's needed in every circumstance. Thank you.
And let me move on. Dana, do you have anything to add to what Cecilia has already said? And maybe thinking about, you know, if we're proceeding in the virtual space, has this also changed what you want to see the parties addressing?
Yes, thank you. And thank you, Mia, and thank you, CPR, for the kind invitation to participate in this today. I agree very much with some of the points that Cecilia made, and I will just add a few other thoughts in the interest of time. I think that, you know, respectful of party autonomy, if the parties both want to submit both closing arguments and written submissions, and they're, you know, committed to doing that, you know, I think the tribunal, you know, typically should allow that. But in terms of like what advocacy seems to be most effective from the perspective of the tribunal, it depends on the size of the case. But one of the benefits of oral closings, I find, is that there's a dialogue between counsel and the tribunal that sometimes allows counsel to bring out aspects of the case or clarify aspects of the case that they may sort of take for granted are clear to the tribunal that may not be, or give them an opportunity to highlight some key evidence that maybe they hadn't highlighted to the tribunal as much as they would have if they realized the tribunal had not focused on that. So the dynamic between the tribunal and counsel at oral closings, I think, can be helpful. The timing of oral closings is an issue. Sometimes, you know, when hearings are in person and everybody's gathered together in, you know, a faraway place because that's the place of the hearing, the oral closing has to, by necessity, take place the last day of the gathering, and that makes for, you know, often an all-night affair for the counsel preparing the closing, and not necessarily the best interaction or most productive experience. In the virtual world, we have more flexibility that one could schedule the closing argument, you know, sometime after. Doesn't have to be long after, but there could be a break to allow counsel to sort of regroup and prepare that oral closing in a more effective way and maybe get a little sleep. So that's one benefit to, I think, the virtual or the hybrid approach. I think that also using technology in a closing allows you to highlight key documents and demonstratives in a way that is harder to do maybe when you're all in the room and the easel is at the far end of the room, and you know, you sort of, the arbitrator takes note, this is demonstrative C, and you know, come back to this later. Whereas when it's in the virtual, you're actually like able to see and appreciate what that demonstrative shows more clearly at the time. So I think I'll leave it at that in the interest of time. I'm happy to take questions.
I'm sorry, we do appear to have a rogue screen share. Okay, I think we fixed that. Thank you so much, Dana. So moving on to Judge Lewis to see if you have anything to add to the points that have already been raised, but also to think about whether there's anything in particular you like in terms of substance you'd like to see or hear in the post-closing submissions.
Well, first of all, thank you for having me. It's an honor to be here. It's always a pleasure to work with CPR and my colleagues, my fellow arbitrators and practitioners and so forth. Ideally, as we all know, arbitration is supposed to be discreet, efficient, and economical. I always hear those principles kind of floating around in my mind as I'm doing anything, when I'm chairing an arbitration panel or serving on a panel or serving as a sole arbitrator. And so so I try to be very careful in allocating responsibilities and approving approaches and that sort of thing. With that having been said, as a former federal trial and appellate judge, it probably won't surprise you to know that I like both oral and written submissions, and I invite them. And some of this is driven by my sense of the lawyers and the case, and what the lawyers really want, and what is really going to be necessary in order to accomplish the purpose of arbitration, at the same time render what I hope is a fair, rational, reasonable award that one party may agree with and another party will not, or that both may not. And so in terms of post-closing, I like to invite written submissions followed by oral argument. I will frequently have the parties agree on a page limit for the post-closing submissions, and then or post-hearing submissions, and then I will convene an oral argument after I've digested. And some of this, by the way, is driven by whether the parties have requested a bare or a reasoned award. If it's a reasoned award, and if I've been presiding for anywhere between 5 days and perhaps 35 days, I mean, the volume of evidence could and issues could also be a factor in determining what I might recommend, or what and how long I might grant in terms of time for parties to do certain things and to present arguments. So depending on those factors, I try to defer to the lawyers and what they think would be best in order to accomplish their purposes, but at the same time operate with the principles that I began with in mind. I do find that written submissions are very helpful in terms of crafting a reasoned award, and so I really do like getting those. I also, by the way, agree with the observation that that demonstratives are really good on a screen. I mean, I didn't know that until we started doing virtual hearings, but it's true that you can see them better. They're right there in front of you, and I frequently have questions during closing arguments when demonstratives are being referred to. So it kind of allows for a more fulsome exchange. So for all those reasons, I like both.
Thank you, Judge Lewis. And I do just want to point out that earlier today, Judge Lewis did remind me that he is one of those arbitrators who prefers having things printed out. So I do like to hear that he also likes seeing things on the screen.
Yes, I do. I mean, I was saying earlier before we started, I'm still kind of old school, and I like to have papers in my hand that I can write on and put question marks on in the margins and so forth. And so I do ask parties to, during the course of an arbitration, to provide both electronic and hard copy submissions so that I can have both available, because sometimes it is better to focus on the electronic.
So moving on to our second issue, we came across the question of, whether there are areas where counsel could do more to elaborate or to focus on the key issues necessary to resolving the dispute. Thinking about in what ways counsel can help highlight those key issues for the arbitrators, and highlight what should be covered in the award. And so for this one, we're gonna start with Dana.
So this shares both my perspective as arbitrator and also as having served as arbitration counsel over the years before going full-time as an independent arbitrator, just as a context. But typically, in my view, good advocacy involves a theme or several themes that run throughout the case. And towards that end, making effective use of the key documentary and testimony evidence that supports the claims and defenses consistent with the theme. So if you weave in the key evidence with your themes of the case, that helps focus the case in a way that is really beneficial to the arbitrators. Also from the arbitrator perspective, with respect to documentary evidence, I think it's really useful when counsel identify the key pieces of evidence that best demonstrate your claims or your defenses, especially in a large case where there's a huge volume of documents. While not oversimplifying your case, I think sometimes, depending on the case, it's appropriate for counsel to say there's, say, 5 or 10 key documents upon which this case ultimately turns, or really highlight the key evidence that that should be dispositive of the case. And that again helps focus the case and the tribunal's attention to what you argue is the key evidence. Similarly, with witness testimony, testimonial evidence, I think it's important and helpful for counsel to assist the tribunal in understanding the business role that each of the witnesses who are testifying had in the matter or transaction that underlies the dispute. I find sometimes too often counsel assume that the tribunal knows who Mr. X of the company is and what his or her role was in the transaction. And so from a very early stage in the case, actually, even at the pleading stage, counsel can set out who are the key players in the underlying transaction or matter at hand, and who will have firsthand critical knowledge, so that as the case evolves, consistent with the themes and the evidence that you're bringing out, the tribunal is expecting to hear from Mr. or Mrs. X on topic Y. And when it comes ultimately to the hearing, we are very acquainted with those key witnesses. Of course, the tribunal will read the witness statements themselves, but the work of counsel as advocates, both in your written submissions and even at conferences or pre-hearing conferences, whatever you can do to tee up the tribunal's understanding of who are the key witnesses and why they are key and what their role is and why they should be given weight, I think is really helpful. And just one last thing I'll mention, and it's really reiterating a point that was made before, is that when there is evidence that can be compiled in a graph or a table or some sort of demonstrative form that makes it much more digestible to the tribunal, and persuasively shows your point, for example, if there's a trend in the price of widgets that's relevant to the case, or a change in the performance of the company that can be graphically demonstrated, or a key timeline, those kinds of things make it far easier for the tribunal to digest the evidence and refer back to it when they're drafting the award. I will just say that for any demonstrative, I think it's really important for counsel to put right on the face of the demonstrative the source material from which it comes. That gives it great credibility. If you just put a graph up saying like, this is sort of, the trend without citing to the specific pieces of the record evidence from which that comes, it has far less weight. And usually most procedural orders require that anyways, but an effective demonstrative really should say on its face the source material from which it comes. So with that, I'll turn it over to my colleagues.
Thanks, Dana. So, Judge Lewis, I wonder whether you have any additional thoughts on this, how counsel can highlight those key issues for the tribunal or for the arbitrator during the proceeding.
Thank you. Once again, I agree with everything that has been said about highlighting key issues. I have a checklist that I use, as most of us who do this work have, that for preliminary hearings and for preparing a scheduling order. And one of the items on the checklist is asks the question, when will the parties provide an agreed upon list of issues? And that is followed by a question whether or not the parties want to provide stipulated and contested issues of law and fact. And I tried during the preliminary hearing to focus the parties on the importance of doing this and cooperating with one another in identifying these issues, because I find that to be very helpful to the arbitrators, or for me as if I'm chairing a panel, in terms of just really getting focused on what I need to do and what I need to allow as everything unfolds. And so by the time we are now into the preparation for the hearing mode and going through various discovery dispute issues and whatever else might arise, I have already identified, or at least the parties I hope have done a pretty good job of identifying for me what I need to have in mind at all times in deciding whatever it is that is being presented, because I understand what the issues are, but they can change somewhat, and some are more important than others. And so by the time we get to the hearing, I will have asked for a pre-hearing briefing, and that will, in light of everything that's happened up until, say, 2 weeks or a month before the hearing, things may have become refined, they may have become highlighted in different ways. And so now the pre-hearing briefs will further identify and focus on the key issues that I need to be focused on during the hearing. And then we have the hearing, and I will have become even more familiar with the key issues, and then we will have the post-hearing briefing. So through all of that, there are numerous opportunities to further elaborate on the key issues and to make sure that we are focused as we should be on what we really must decide. So it's a give and take, but the arbitration panel or the tribunal plays a key role in inviting the parties' joint participation in that process and in refining it as things unfold, and then ultimately in focusing on those and rendering a decision.
Thank you. So Cecilia, do you have any different takes on this? And in particular, what are your thoughts on, as Judge Lewis mentioned, having a list of issues that might be submitted by the parties? And if so, what stage of the proceeding should that happen at?
Well, I agree with all that has been said. I would just say that I would share my experience. I guess everybody, it's an overthinking when talking about the list of issues given by an arbitral tribunal to address in the closing submissions. And everybody is like, oh my God, they are not buying this argument, or what do they mean with this question? We thought we had left these points super clear, or we should really make a very deep examination about these points. So everybody's wondering about what is on the mind of the arbitral tribunal. And well, sitting as arbitrator, I have seen very interesting things. For example, I have found that some parties are, when they have these issues to be addressed, they talk completely about a different thing I have also found other parties that really get the question and address it in a fantastic way. And sometimes even the parties are reluctant, or they don't know how to address that question. And they ask the experts to complete a report about that question. And I think that might not be appropriate, because they are like overusing that opportunity that the arbitral tribunal gave them to address particular topics. And it's not the opportunity to file another expert report. It doesn't matter, it's just on a particular topic. About the timing for doing that, I think, well, of course, it's good to have it at the end of the hearing, but also I think we should consider about doing it on an earlier stage. And it will also help the counsel prepare their arguments in a more effective way, and also the arbitral tribunal to prepare better for the hearing on and for, of course, writing the award. And well, I would leave it there. Thank you.
Thank you so much. Before we move on to our next question, there was a question in the chat from Albert asking, does the judge find written submissions are less useful when drafting a full-blown opinion? He focused his remarks on reasoned opinion. So I guess the question here would be, Judge Lewis, whether the written submissions can be more or less useful depending on how fully fledged that award is.
Yes. So I saw that question, and I just happened to have on my desk here in my office an example of why I think the answer is yes. My answer is yes, I do find them to be very helpful. I am holding in my hand, there are no names on it, just claimant's opening post-hearing brief. It is 63 pages long. In an arbitration I presided over recently that was about a 3 or 4 week hearing, and it is a full-blown brief that summarizes evidence. It cites important cases. It does a very effective job, I think, in identifying important issues that I need to decide, and why I need to decide, and what I need to refer to, and so forth. I find this to be very helpful. I'm sure I will, in drafting an award. I mean, I'll get a response brief, and then a reply brief, and then another brief and a reply brief, and so forth. So in this is a very complicated case, and I want to rely on whatever the lawyers think I need to really know and understand in order to render an award in this very difficult case. So the answer is yes, I do find written submissions to be most helpful when I am asked to prepare a reasoned award. That award could be anywhere from 10 pages to 50 pages, and depending on the issues, or more. And I know we're going to talk about that I think we're going to talk about length of awards or something like close to that in our discussion. But I find it to be very helpful because I'm reading, I'm holding it in my hand, I'm leafing through, I'm looking at the cases that are cited, I'm researching, I'm doing everything that I would do, for example, when I was on the Third Circuit Court of Appeals in fashioning an opinion, or when I was a district court judge after a trial in writing an opinion. And as I guess lawyers become accustomed to in our profession in presenting argument to a panel that's going to make a decision, I just find written to be more helpful. But I like to augment that with obviously with an oral argument too, as I said before. I hope that answers the question.
Thank you. And we're going to stay with you for our next question, Judge Lewis. So our next issue, we wanted to discuss what weight should be put on expert testimony. So when the parties are preparing, are presenting their experts, what weight should be put on that expert testimony, and how does the tribunal view that?
Well, that depends is my answer. Obviously, all testimony is important for the arbitrator to understand, evaluate, and weigh. Expert testimony, to me, deserves sometimes a special treatment because of the expertise of the person who is providing the information and the importance to the issues that I've been asked to address. But really, it depends on how complex the matter is. It depends on how unique the matter might be, whether it's a very complicated business dispute involving, for example, features of the international banking system, or whether it is something else that involves healthcare that I had never heard of before, and most people will never have heard of before. Whatever it might be, it depends on how unique. It also depends on how experienced the expert is and how qualified I sense that person might be. And often there are, as you know, there are challenges to the qualifications of an expert before the expert testifies that raise red flags or raise certain issues. I may still allow the testimony, but those red flags are still there. And as I'm listening to the testimony, I may go back to some of the questions that were raised before and ask the expert to elaborate on something, and it may impact the weight that I place on the expert's testimony. It depends on, to me, on how important the expert testimony is really. I mean, sometimes parties call experts where they really are not needed. How important is this really, and how meaningful? And so those are the kinds of considerations that I use when I'm evaluating expert testimony. And I do look at it differently from lay testimony, as I think we should, if an expert is qualified. And I try to understand that the expert, after all, is there to help me make a decision, albeit from the perspective of the side presenting the testimony. And as you know, there are different methods of presenting expert testimony. There's hot tubbing experts, and there's my preference is to have the testimony presented as I would if this were an actual trial. I mean, I guess I still have that federal court bias when I'm doing this sort of thing. That's my preference. But if I'm on a panel and the chair or another panel member says, "Oh, no, we should hot tub these experts and have them go at each other," whatever, that's fine with me too. But I'm just telling you what my preference is. And so anyway, that's how I evaluate expert testimony.
Thank you so much. Cecilia, do you have any other thoughts on expert testimony and how it can be effective?
Yeah, thank you. Well, I think there is not a clear-cut answer as to what is the right way to give to expert testimony. And it really depends on each arbitrator and, of course, each tribunal, each background and each different legal tradition. I mean, if it's civil law or common law, and it also depends the case. And this is so true that in experts interrogation, the first thing the parties try to do is undermine the credibility of the expert, so that the arbitral tribunal does not take his report so seriously or his testimonies so seriously. And well, this is achieved by trying to find out whether the expert really received the some coaching from the party or not, and how truth it is, or how technical the question is. I would always try to use the hot tubbing, and in order to when you have both experts arguing between each other a technical matter, you will find out with your all reasoning which is the way to give each other. And of course, it's not that you are relying, and you shouldn't rely on an expert testimony, but using your knowledge and your common sense, you can understand which of the expert reports is accurate, it's truth, and of course, use that in your own words and in your own understanding, and use that in the award, and of course using that to ask questions to the parties and to the experts. Thank you.
Thanks, Cecilia. Dana, any other thoughts on expert testimony before we move on to our last issue?
Yes, well, I think that the points raised by Judge Lewis and Cecilia were both very, very useful, and I agree with them. I think one tricky area when it comes to experts is when the experts are, to some extent, like ships passing in the night, and they're not really addressing the same issue. And then it's incumbent on the tribunal to try to guide, or more than guide, encourage counsel and the experts to ensure that to the extent that expert testimony is key to an aspect of the case, and that the expert testimony really be apples to apples, so to speak, that address it in a way that can be evaluated by the tribunal, both sides experts, and sometimes that's easy, and sometimes that's not easy, and the experts actually have to go away and work together and come back with a joint something, or there's hot tubbing can achieve that to some extent, but hot tubbing is a very sort of spontaneous, interactive exchange that sometimes yields really useful information, and sometimes is less useful because it's just not, unless you give the experts some notice, even a couple hours notice, like tomorrow when we hot tub, these are 5 key issues we want to talk with you about, or something. The hot tub can be so spontaneous that it's less effective than it otherwise would be. So I also think when tribunals decide to hot tub, or when hot tubbing is, I guess, jointly agreed by everybody, it's really helpful for the tribunal to spend time together in advance to decide what areas to cover, and if possible to share with the parties those key areas, so that the most is made of hot tubbing. But I do think that expert testimony can be extremely valuable in cases. Sometimes guidance is needed from the tribunal to make it as valuable as it can be. And I think that the tribunal often confers amongst itself to try to identify where they see holes, or a missing link to understanding what the expert testimony is supposed to establish, and then invite the counsel to address that.
Thank you, Dana. Before we get on to our last issue, I do want to take a moment to give everyone our CLE word. For those who are going to be requesting CLE credits, the code word is award. So please write that down. There will be a survey circulated shortly after the program with a link to enter the CLE code word, which again is award, so that you can request your credits. Okay, so moving on to our final issue, lightning round, so that we can have a little bit of time left for Q&A at the end, is a jurisdictional question. Should the parties address criteria necessary for the jurisdiction where the award will be enforced? Or is that something that should be solicited by arbitrators only when needed? And so I'm going to start this one with Dana.
Yes, this is an issue that came up in connection with the Rules Revision Committee work that I was involved with for CPR when CPR updated its administered arbitration rules and its non-administered arbitration rules. And it was really a very diverse international group that comprised the committee for the rules revision work. And this issue came up that what if the award is going to be enforced in country X where there are some specific requirements with respect to the award? So I don't know if I characterize it so much as a jurisdictional issue as a, enforceability of the award issue. Maybe that's, sort of gets to the same point. And the issue that was discussed is, is it incumbent on the arbitrators to anticipate where this award may be enforced and then sort of diligence what's required in country X for an award to be enforceable? Does it need, and I'm just sort of, exaggerating for the purpose of illustration, does it need, to be initialed on every page? Does it need a seal? Does it need blue ink original signatures? Like, what is it that in country X or in that jurisdiction is required for an arbitral award to be recognized as a court judgment and enforced? And, I think the upshot of the discussion was that it's really not necessarily appropriate for the tribunal to speculate on where any resulting award is going to be enforced across the world. That's much more within the purview of the parties and counsel. And so what might be appropriate in an international context where there are parties from various parts of the world and potentially assets at issue around the world is if the parties or the counsel anticipate that the award may be enforced in a certain country, for counsel to actually take the initiative and provide information relevant to making the award enforceable in that country, whether it be initialing or blue ink signature or the like. And I think that sort of goes to party autonomy and it's the parties' arbitration and they want the award and they want to be able to enforce the award and they sort of know much more about the backdrop of how this dispute came to be than the tribunal. I think that if put to the tribunal, there's a possibility of enforcement in various places. And so we would invite the tribunal, even with a lack of specificity as to where, but you could invite the tribunal to, in issuing the final award, to take the following procedural steps or include the following aspects. I think that would be very helpful to the tribunal and obviously for counsel very helpful to your clients. So that's how that came up. I think that's how it came up in our sort of pre-panel discussions, and it's something to keep in mind.
Thank you, Dana. Judge Lewis, do you have any additional comments on that to add?
Only this, I agree with everything that Dana just said. She is absolutely right. And as she has alluded to, this is obviously more likely to happen in the international realm. I think that it is incumbent upon counsel to address this issue with the tribunal and to raise it with the tribunal. My short answer to your question is I do not believe that it is incumbent upon the tribunal to the extent that the question suggests it might ever be. I don't think it's incumbent upon the tribunal to raise this issue. I do think that it is likely, it is clearly foreseeable that a tribunal would raise it in fashioning the award, and for whatever reason, a consideration arises, well, wait a minute, hold on, how is this going to be enforced? But I think that in the first instance, it really is counsel's responsibility to advise the tribunal and to bring this issue to the tribunal's attention rather than the other way around. I mean, that's a short answer to your excellent question, but I agree with everything that Dana said.
Thanks so much, Judge Lewis. Cecilia, do you have any thoughts? I know so much has already been said on this.
No, not really. I also agree with Dana and with Judge Lewis. Thank you.
Great. Well, it looks like we've gotten through all 4 of our questions. And so I do want to open up the floor to questions before we let the panelists give us any parting thoughts. I do see another question in the chat, so maybe we'll start with that while everyone else in the audience thinks, and please feel free to raise your hands. The question is, if expert reports are simultaneously exchanged, do the speakers favor rebuttal reports, or in the interest of efficiency and economy, save the experts' rebuttal views for the live hearing? And I'll let anyone who wants to take this one.
I'll be happy to start because I think I began with efficiency and economy, and let me be very clear about what I mean. As we all know, sometimes lawyers become very aggressive in presenting arguments to a judge or to a panel, or and sometimes this can take the form of raising issues that really need not be raised. They could be easily resolved by a phone call or by just spending a little bit of time trying to work something out. But no, instead, the idea is to get in there and slug it out. And I frequently tell parties, you do not really need to bring this to my attention. And because when you do, I'm going to have to convene a hearing. We're going to have to address it. I may have to write something, and it's going to be very expensive for your client. And you're going to be billing the whole time too. And it's just not necessary to do that. So please be mindful of this at all times. That's really the kind of thing that I'm talking about. With that having been said, I really invite lawyers and parties to pursue aggressively their issues and their case, and that would include, in answer to this question, where appropriate, rebuttal expert reports or rebuttal of any kind. I mean, I think that the idea is to fully educate the people who are going to be deciding these issues, fully educate, and because we are presumably coming in knowing nothing about this, and so if something comes up and it deserves to be rebutted, by all means, I have no problem with that whatsoever. But I don't think that once the tone has been set about at the very beginning about efficiency, economy, and that sort of thing, and trying to just keep the hyper aggressiveness to a limit within certain limitations, which sometimes requires a panel to continually remind parties, please, you could have done this without presenting it to me. You could have worked this out pretty as easily as it's going to take me to say no or to say yes, whatever. You know what is likely to happen here. That's all true, but that doesn't in any way mean that the parties are willing to and think it might be helpful to engage in rebuttal arguments and rebuttal experts and that sort of thing. I have absolutely no problem with that at all. That's just me.
Thank you. And I know Dana also wanted to answer this question. Dana.
Yes, so I agree with Judge Lewis. I think that's with everything that's been said. I do think that rebuttal reports can be and often are effective, especially when you have ships passing the night with the opening expert reports. But additionally, I think that at the hearing, the opening presentations that have become more conventional, instead of relying solely on the expert reports, but actually having a short presentation from the experts at the hearing where they really hone in on the key aspects of their expert testimony is hugely helpful to the tribunal and to everyone involved, because the expert reports are, inevitably long with, 250 footnotes, and when you really try to boil it down and find common ground, what are the key issues and what are the differences between the parties, those opening presentations can be really helpful.
Thanks, Dana. And I see we have a raised hand from CPR's president and CEO, Alan Waxman.
Thanks, Mia. Thank you, everybody. Really a wonderful presentation, and thank you for sharing these very valuable insights. I did have a question, kind of parochial to being a provider, which is about providers doing reviews of your awards. Do you have perspectives on that? Is that something you find useful? Would you like to see it done differently, not done at all? I just would be interested in your own take on that.
Sure, Cecilia.
I would like to take the lead here. What I really appreciate from the parties is that they have a structure when they are presenting their case, to have a document well organized, titles, subtitles, a table of contents, and also the most important thing is that they have a structure of their case, that this thing gets you to the other, and they explain things clearly. There's nothing worse than receiving a 500-page memorial with everything just receiving a mess. It's also good to have the numbered annex and maybe a file with the IE file with everything very clearly presented. I really appreciate that from the parties.
And I just want to take a moment to thank Dana, who had to drop off because she is so in demand. She had another speaking engagement starting at 1 over in Ireland. Luckily, we are virtual, so I believe she's doing this from the comfort of her home and didn't have to travel halfway across the world in 30 seconds. But I do, Judge Lewis, want to see if you had any additional thoughts on Alan's question.
Only this, I sometimes find it to be very frustrating, but there's nothing wrong with another set of eyes reviewing an award, presumably with the idea of improving it or finding certain things that might be. I mean, you know, there are some arbitration providers, and I won't mention any names, that are really aggressive about that and have, and I, as someone who as I've mentioned a number of times, likes to let the parties kind of do whatever they think is right, and I like to try to do what I think is right. The rules are, I get a little frustrated with these rules sometimes, but they're there. We agree to them. We try to adhere to them, and so it's a good thing in the long run. And it's also good for the arbitral providers too, because they want some consistency in how these things are accomplished and done. I presume that that's what your question is directed at, Alan. I may be misunderstanding, but
no, there seems to be different levels of review. You're sort of getting at it, and I'd love to hear more about the frustration. There's there's more perfunctory reviews, there's more searching reviews, there's more editorial reviews.
So I was having a conversation recently with someone because they overheard a nationally televised interview in which someone used syntax or something. And I said, come on, you know what they're saying. Why do you have to stop and criticize this misuse of the English language? You know exactly what their point is. And I kind of feel the same way when we talk about this, but you have to follow this format and you have to list it this way and do that. It can be a little frustrating, but I understand, and there has to be some uniformity, and it is, I think, important, because otherwise you might have rogue people doing things that they should not be doing. So I don't know. I hope that answers your question.
It does. Thank you.
So for those of us who have a little bit more time to stay on, I want to bring up one more question that we had here. about the question from the chat is, could you shed some light on assistance in writing awards? I don't know if if you want to elaborate on that, feel free to pop on the screen to tell us what aspect of assistance in writing awards you're talking about.
Yeah, hi. Thanks for taking my question. I'm dialing in from India. And I've only seen this in books that there is, a scope for assistance in writing of awards. Practically, what I've heard here is certain arbitral tribunal, they take help of, some sort of like our version of paralegals. But how does this work? Like as a service is, because I know writing of the awards is what takes the longest. So is there some scope for institutes to come in there?
May I address that if you don't mind, Cecilia, because I actually do this a
Of
lot.
course.
Thank you. I actually do this a lot. If I am a chair of an arbitration panel, or if I am a sole arbitrator in a matter, as opposed to a party-appointed arbitrator on a panel, I ask the parties if they will approve my use of a law clerk to assist the panel or to assist me as the arbitration unfolds and through the hearing and through the drafting of the award. The reason I do that is because in the end, it actually, have found over the years, saves the parties money and saves time. What I'm talking about here is the use of a law clerk who might be who would be an associate at my law firm to research cases that are a part of the submissions and to assist in drafting certain things, doing a first draft for the panel to review. I mean, nothing gets out without me really signing off and approving everything. But I do find that it can be helpful to the parties in terms of time and efficiency and money to have someone charging a far lesser rate than I might be doing research, because we review all the cases and everything else that's included in all the submissions. And whatever when it comes to drafting an award, I will do a first draft of an award, and then I will invite the associate to assist in helping to put it all together in a way that is close to being ready to I think it's a 30-day filing rate period with certain entities, and with others it can be different. But so that's my use. And I find that it's very helpful to the panel, and it's very helpful to me, and in the end, very helpful to the parties. I've never had an objection to doing that. I've never had there's never been an instance where somebody else's thinking is being substituted for mine. And so it works very well. I hope that addresses your very good question.
I would like to add something. I, of course, agree with Judge Lewis, but also I would say that we have a kind of responsibility with the next generation. And having a secretary of the arbitral tribunal will help those next generations to learn how to draft, how to reason, how to understand the parties' arguments. What it is of the utmost importance is that we as arbitrators never delegate the responsibility of deciding and studying the case in a secretary. It's just kind of help and letting them help you put together the award, for example, the table of contents, the titles, and have it very well presented, and make the research and help you with maybe the annexes or everything, take care of that. But I'm sure Judge Lewis will agree with me. It's just a matter of help, but not delegating the responsibility to them.
Precisely. And I do see a really good question here. Judge Lewis's comment about assistance raises the controversial topic of whether an arbitrator should do his or her own research. And that's an excellent point. I want to emphasize that nothing is written, decided, or done without me having fully digested everything, including what the cases say and what they mean and so forth. As I mentioned before, I used to sit on the United States Court of Appeals for the Third Circuit. I had 3 law clerks who were assisting me at all times in drafting bench memos, doing first draft of opinions for panels on the court and so forth. This happens at the United States Supreme Court also. I mean, it's only controversial if you are, as I said before, allowing your views to be substituted for someone else's, which should never, ever happen, as Cecilia just pointed out. But the idea of assisting in doing research and looking up cases and talking about them and so forth, I don't think it's quite as controversial as the question suggests. I actually think it's just very helpful to everyone to have that capacity, but it is a good question.
I see that we are, already 10 minutes over, but I see another question in the chat. And so if the panelists don't mind staying on for one last question, we have from Sarah Beiser, what do you do and recommend to do when one party wants post-trial, post-hearing briefs and the other party does not? It's a great question.
I think it's a great question because remember, as I keep saying, we keep talking about, people are paying for this service. And so I don't know whether the party that doesn't want to do that has heard from the client, we have a budget and we cannot go above this amount. I don't know necessarily what the reason is why a party may not. So I would probably in that instance say, well, if that's the case, if both parties don't agree, then we won't have it unless I sense that it is really going to be important to assisting me in making the right decision here to have some post hearing briefing. So I may, if I sense that, grant it anyway and limit it considerably because of an objection. But my first response would be to say, okay, fine, because we won't do it because I don't know. We have to be very mindful at all times of the issue of costs, and this can be very, very expensive. It's not supposed to be, but it can be.
Yes, of course, it's having a balance between the usefulness and the cost it will take doing that.
Great. Well, I do want to thank everyone for joining us today. I want to thank the panelists, especially for these really insightful discussions on the issues we raised today to help all of us become better in the process. And I do want to thank our participants for the lively questions, especially those of you who managed to come to all 5 of our sessions. As this is our last one, we're going to be closing the 2022 skills training from CPR, but do stay on the lookout. If you missed any of them, we're going to be putting them together and releasing all 5 for everybody to be able to view on their own. And next spring, we hope to be providing next year's skills training as well. So thank you to everyone for their participation. Thank you especially to our panelists.
Thank you. It's an honor and a pleasure. Thanks.
Thank you.
Okay.